and welcome to Rajput, Jain and Associates. Today in this video we will be discussing about prepack insolvency. So let us begin with the meaning of prepack insolvency. A prepack is a way of resolving the troubles of creditors and owners of distressed businesses. Under a prepack resolution, the owners and creditors of a business agree to sell the business to an interested buyer before to the court to sanction the agreement. It has evolved over the time differently in different jurisdictions, and every jurisdiction has a unique variant of prepack, which allows the stakeholders to modify it further to an extent to suit their needs. So, what was the reason for introduction of prepack insolvency? The prepack option has been introduced to help micro, small and medium enterprises which have been hit hard by COVID-19. According to sources, prepacks are largely aimed at providing MSME with an opportunity to restructure their liabilities and start with a clean slate while still providing adequate protection so that the system is not misused by firms to avoid making payments to the creditors. Now, having discussed about the meaning and need of prepack insolvency process, we now come to the eligibility criteria which the corporate debtor must comply with for initiation of prepack insolvency process. So firstly, the proposed corporate debtor must not have undergone prepack insolvency process or completed the corporate insolvency resolution process during the 3 years preceding the date of application for prepack insolvency process. Secondly, apart from this, no order for liquidation be passed in the name of the proposed corporate debtor. Thirdly, the corporate debtor must be eligible to submit a resolution plan under Section 29A of Insolvency and Bankruptcy Act 2016. Fourthly, financial creditor must have proposed an insolvency professional by providing at least 66% votes in favor. Lastly, the majority of directors of the company or partners of LLP must have made declaration in the prescribed manner. Next, we come on to the process of prepack insolvency resolution. Before starting with the process, the applicant entity shall ensure that the corporate debtor should be an MSME under Section 7, subsection 1 of MSME Act 2006, and also the default by corporate debtor should be of minimum of rupees 10 lakhs. Now, where the corporate debtor complies with the above conditions, the same shall obtain the approval of directors of company or partners in case of LLP. After that, a special resolution be passed by the members approving the application for prepack insolvency process. After this, certain declarations are required from directors of the company or partners of LLP, which will be supplied along with the application. Then, the approval for appointment of insolvency professional as the resolution professional be made by the committee of creditors, and for this committee shall approve the same by 66% of voting. After obtaining approval, the corporate debtor should make an application to the adjudicating authority for initiation of prepack insolvency resolution process. On receipt of application, the adjudicating authority shall admit or reject the application within 14 days. In case of any clarification is required by adjudicating authority, the same shall be clarified by the corporate debtor within 7 months from the raising of query by the authority. On receipt of the reply from the corporate debtor, the adjudicating authority shall either admit or reject the application. Now, in case the application is rejected, the prepack insolvency process do not commence. And in case the application is admitted, the prepack insolvency process will commence from the date of order of adjudicating authority. After accepting the application, the adjudicating authority will declare a moratorium appoint a resolution professional, and order for a public announcement regarding the initiation of pre-PAC insolvency process, which is to be made by the appointed resolution professional. Now, the moratorium will continue to hold from the date of order of adjudicating authority to the date on which pre-PAC insolvency process comes to an end. So, after passing of order, the corporate debtor shall submit the list of claims, preliminary information memorandum, and base resolution plan to the appointed resolution professional within 2 days from the commencement of the process. After this, the resolution professional shall constitute a committee of creditors within 7 days from the process of commencement date. Then, first meeting of committee of creditors be called by resolution professional within 7 days from the date of constitution of committee of creditors. Now, in the meeting, the resolution professional shall present the base resolution plan to the committee of creditors, and committee shall approve or reject the plan. So, if the committee approves the plan, the resolution professional shall file the plan with adjudicating authority for approval. However, in case the committee rejects the plans, the resolution professional shall invite other plans. Now, the committee of creditors are required to select any one resolution plan from the plans submitted by the resolution professional within 90 days from the date of commencement of the process. So, once the committee approves the plan by at least 66% voting, the RP shall submit the proposed plan to the adjudicating authority for approval. Now, the adjudicating authority has the final say on the resolution plan. So, in case the adjudicating authority approves the plan, the pre-PAC insolvency process stands completed. And in case the adjudicating authority rejects the plan, the same shall order for the termination of pre-PAC process and order for initiation of liquidation of corporate debtor. So this was all about pre-PAC insolvency. For more details, contact Rajput, Jain and Associates. You can also visit our website www.carajput.com. Thank you.